A new court ruling could severely limit legal challenges under the Voting Rights Act. A federal appeals court threw out a lawsuit by an Arkansas NAACP chapter challenging a redistricting plan they say would dilute black voting power in the state. The court says only the federal government, not private citizens or groups, can bring a case like this. Let's bring in senior Washington reporter Devin Dwyer, along with ABC News legal contributor Kim Wehle for more. Now, Devin and Kim, thank you so much for joining me. Devin, what went into this decision?
Yeah, Stephanie, this was a decision about who can sue to enforce the Voting Rights Act. For 40 years, individuals and civil rights groups have been able to bring challenges to voting laws, election maps that they allege have been discriminatory on the basis of race. And courts at all levels of the federal system have decided those cases. But here yesterday in the 8th Circuit Court of Appeals, a judge appointed by Donald Trump, former clerk to Justice Clarence Thomas, said that reasoning that individuals and civil rights groups could bring these cases is on flimsy footing. Judge David Strauss said that, in fact, the text of the Voting Rights Act only names one person explicitly who can enforce it. That's the Attorney General. He said the fact that the law doesn't name anyone else means no one else can bring a challenge to a voting law in a given state under Section 2 of the Voting Rights Act, and therefore he tossed out this challenge by the Arkansas NAACP, as you said, and blocked it from going forward. And this is a major decision. If this were to stand, it would upend decades of process around the Voting Rights Act and really limit the ability of individuals and civil rights groups to challenge voting laws.
Wow, a key part of the Voting Rights Act. Kim, what do you make of this ruling?
Well, it's really bizarre, given that the United States Supreme Court just decided a case called Allen versus Milligan, in which they, in a 5-4 decision, upheld a challenge to gerrymandering in another state under the same statute. So on the one hand, it's a technical, sort of textualist reading saying only the Justice Department can bring these cases. But on the other hand, it just ignores decades of precedent, including out of the United States Supreme Court. So it'll be weird to go to the court and say, by the way, what you've been doing is somehow illegal. But it does also put pressure on the Department of Justice to start bringing more cases, and they just arguably don't bring enough.
And Devin, as you mentioned, this could go to the Supreme Court. So what are the next steps?
Well, the NAACP, Stephanie, could appeal to the full 8th Circuit. This was just a 3-judge panel of this appeals court that decided this. It was a 2-to-1 decision, so they could attempt to get another look at this at the appeals court. But in any case, this is likely bound for the Supreme Court. It would likely arrive at the Supreme Court next year, which, of course, is a major presidential election year. So a lot on the line there. And we know that Justices Clarence Thomas and Neil Gorsuch have previously indicated their openness to reconsidering the ability of individuals and civil rights groups to bring these kinds of challenges. So already 2 members of that court are skeptical, but as Kim was just talking about there, you know, it's sort of one wonders what the rest of the court will think about this, especially since just last term, as she said, and in other cases over the years, the court has taken up these issues and decided them. So we'll have to see.
All right, we will see. We will certainly be watching to see what happens. Devin and Kim, thank you so much for joining us. Really appreciate it.
Hi, everyone. George Stephanopoulos here. Thanks for checking out the ABC News YouTube channel. If you'd like to get more videos, show highlights, and watch live event coverage, click on the right over here to subscribe to our channel. And don't forget to download the ABC News app for breaking news alerts. Thanks for watching.